All right, well, good afternoon, everyone. Thank you for joining us for the third and final webinar in our special asset summer school series. This session will cover the topic of commercial foreclosures. I'm Haley Upton, Marketing Coordinator of Events and Proposals at Ford & Smith, and I'll be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via Zoom chat feature and I will try and troubleshoot with you. Our speakers are happy to take questions during this webinar. If you have a question, please type it in the Q&A box and it will be addressed at the conclusion of the presentation. We have left time for Q&A at the end. Allow me to go ahead and introduce our speakers today. Paul Fanning leads the Creditors' Rights practice and is certified by the American Board of Certification and the North Carolina State Bar as a board-certified specialist in business and consumer bankruptcy law. His practice experience encompasses bankruptcy, collections, creditors' rights, and lender liability. He concentrates his practice in the representation of creditors in complex bankruptcy cases and state court litigation, including workouts, collection reorganizations, and contested matters. Thomas Wolf's practice encompasses a wide range of creditors' rights, law, and business transactions. His creditors' rights experience includes representation of financial institutions, lenders, community associations, and other creditors in collections and bankruptcy proceedings, as well as navigating commercial loan transactions and workouts. Thomas routinely represents creditors in commercial litigation in addition to drafting complex loan and settlement documentation. Hope I did you guys justice in those introductions, but I will now turn this over to Paul so that we can begin.
Thank you, Haley. I appreciate the opportunity. Thank you for all the work that you've done to put this together. And thank you, all of you out there. I had a sneak peek at the list, and I've got to say that this is a very knowledgeable group who is watching this webinar. It is only my hope that you can find a nugget of information that you are learning today or have forgotten about over the course of your work history. Start us out. I'm glad to be on with Thomas. Thomas is a rising star, and one fun fact for us to share is that we both have twins. We both have one of each twins. And no, they're not identical because they're different genders. So today we're going to talk about commercial foreclosures. We're going to include in here some strategy tips, and hopefully you'll find them useful. The name of the game, as I always say, is maximize your recovery while minimizing the risk. So we are going to cover commercial foreclosures. This is primarily geared toward North Carolina law. Both Thomas and I are licensed to practice in North Carolina. The concepts could apply in any jurisdiction, but there are specific procedures and laws that dictate how commercial foreclosures need to happen in those different jurisdictions. This is commercial foreclosure. We're not going to be talking about consumer law, the CFPB, all the regulatory spider webs that you get into when you're trying to foreclose on consumer property. We do have Q&A afterwards. You can send us a question. We will try to address it at the end of the presentation. Of course, you can always call either one of us offline, and happy to talk to you about any specific situation or question. So jumping right into it, Haley, if you would pop into the next slide. What we typically do is we have prepared a client documents checklist that we send to our clients for them to use when they send us new matters. This is designed to be a useful guide so that they put together all of the documentation that we might need in order to do a proper document review. If you don't have this and you want a copy of it, you can email us and we'll send it to you. It's a very useful guide and very helpful to begin that process. Right now, Thomas is going to move through kind of the steps of the foreclosure process before we dive into the specifics and some of the strategies. So Thomas, here's your intro.
Thank you, Paul, and thank you everybody for being here today. As Paul said, I'm going to try to go through just a 1,000-yard view of the foreclosure process from start to finish to provide just a little bit of background. You know, we are well aware that most people here today are very well versed in the process, but as with everything that we do, you try to start and begin with the ending in mind. And so much of the strategy and decisions we make at the beginning of the file are impacted by all of the different steps involved in the foreclosure process. So find it a good jumping off point, just as a reminder to go through the different parts of the process, why they're important, and just kind of give us a little bit of background for what we're talking about here today. So on the next slide, first topic is the due diligence. When we get a file in, obviously we will do a comprehensive document review. We want to try to get ahead of any issues before we get into the foreclosure and they're brought to our attention by someone else. You know, best to know what we're getting involved with and how to address it at the front end. We will conduct all sorts of searches, including a bankruptcy search on any of the obligors and borrowers, guarantors, anybody with interest in the property. We want to make sure we're avoiding any bankruptcy stay, injunction, or discharge issues that may grind things to a halt later on and cause further grief. Same with military searches. The North Carolina statute prohibits us proceeding against active duty military members without going through certain hoops. So it's important to know what everybody's status is before we get started to make sure, again, we're not getting any surprises down the road. One of the more important due diligence items is to perform, obviously, a title search. A lot has happened potentially between the time that the deed of trust was executed, title passed to the borrower, and now. And so we need to go in there, take a look at any other deeds of trust that have been filed, any second liens. We want to look for tax liens, judgments, and anything else that might pose an issue in the chain of title. Anything that might be subsequent or intervening, and those sorts of things on the front end before we got involved. Try to get ahead of any priority issues. Make sure the bank is where they expect to be. You know, if we're in first position, we want to make sure that's where we are. If the bank thinks they're in second position, we want to make sure nothing is out there that we didn't know about beforehand. And another and final issue we want to look into are environmental issues. And normally the bank's going to have a good hold of this. If you got property that is a gas station or something like that, where there may be significant environmental issues to be aware of, we want to make sure we point that out in the front end, because it's going to be a big strategy piece on how we proceed, whether or not the bank wants to eventually purchase that property and deal with the financial burdens that come with handling those environmental issues, or taking title of the property that's less than desirable. Second item, initial demand letter. That's essentially there as a statutory process to make sure that we are clicking off any boxes to provide the borrower with a right to cure if the loan documents require it. To make sure the bank can secure their attorney's fees in the case, we have to provide at least 5 days notice and give them a chance to pay the balance in full to be able to recover attorney's fees. And that's one of the primary reasons for sending that initial demand, is to start that time running, so the bank's not missing any steps with that. And finally, assignment of rents provisions. if you got an assignment of rents, we want to make sure we're sending out notice to those tenants that we're about to begin the foreclosure process. And in the meantime, all those payments need to start coming into the bank, and all payments need to stop going to the actual borrower. Substituting the trustee. It's a critical part of the process. I'll talk about it a little bit more later, but in North Carolina, deeds of trust have a third party in the middle that is a neutral and objective party to help oversee essentially the foreclosure process. They handle the actual foreclosure and the sale. We represent the bank's interest in that matter, but North Carolina is unique in that they require a third party to be in the middle of the process. So the first thing we need to do is substitute who was the original trustee when the deed of trust was recorded, with somebody that we're familiar with working with, somebody that's going to help with the process now. And then we send a final demand to check off one more box of the statutory elements. Essentially, we need to give a full breakdown of everything owing on the loan, breakdown of the principal, interest, other charges, legal fees, everything that's owing on the loan before we can start that foreclosure process. And that has to be sent within 30 days of making our filing with the clerk of court to begin the process. So after that demand letter has gone out, next slide, please. The notice of hearing is the first official document that's going to get filed with the court to actually begin the process. As you know, in North Carolina, the foreclosure process, being non-judicial, is not done in court, but it's done before the clerk of court. And so the first thing we file is a notice of the hearing, and the hearing is going to be held on whether or not the bank's documents and has followed all the procedures and it's entitled to proceed to foreclosure. That's the first thing that's filed, and we need to serve it on all the interested parties in order to move forward. At the foreclosure hearing itself, as I said, it's going to be held before the clerk. Usually there's going to be in that room us as representing the bank, the trustee, and the debtor's counsel. And actually you can go on to the next slide. Sometimes there's a guardian ad litem if there's a deceased party with some unknown heirs. Sometimes there's other parties that are interested in the lot that will attend that hearing, but the main parties in the room are anybody that's obligated to pay on the debt, the bank, and the substitute trustee. It really is going to depend on the situation. And you can skip ahead into to the foreclosure hearing on the slide, please. There is, or did we get one step too far on those slides? I think I might have gone ahead one more.
You just do your presentation.
Sorry.
Haley, you back up too, please.
Give me just if you guys give me just a second, I apologize. Let me.
That's all right. I will do my best to submit the information without the slides anyway. Sorry if I pushed us off track there.
No, not at all.
At the hearing, the goal is to get an order from the clerk that's going to entitle the bank to sell the property at the actual foreclosure sale. That's entered if 6 elements are met. You got to show that the bank is the holder of the valid debt, which is shown with a promissory note. You need to show that there was a default, which is typically shown when we have our demand letter sent that there's not been payment. We've got to show that there's a right to foreclose under the power of sale provision in the deed of trust, which is usually contained in the deed of trust. We got to show that we provided the adequate notice. We got to show that in this context that it's not a home loan, that is a commercial loan. And again, show that there's no active duty military member entitled to be there. So long as all those 6 boxes are checked, the clerk's going to enter the order allowing the foreclosure to proceed. After that, it's a matter of setting the sale. Again, this is a very routine and statutory process. There's a document prepared that gives notice of what is being sold, where the sale is going to be held, what time, the date, and any other information that any party interested in purchasing the property is going to need to know. There's certain ways that's published and sent out. Again, going to get into this in a little more detail later on, but the idea is that the notice is posted in certain ways to provide interested parties with any information they need to be able to show up and bid. Then obviously the sale finally occurs. Assuming all the correct boxes have been checked, all the notices have gone out, the bank can credit bid at the sale to protect their interests. A borrower can buy back the property at the sale, and a third party can purchase the property at the sale, all which are potential results. In order to buy the property, the winning bidder is going to be required to make a deposit in certified funds of either $750 or 5% of the winning bid amount, whatever is greater. If they don't pay that at the time of the sale, the property can be offered up for sale again. That really depends on the situation, but generally most bidders show up ready to pay whatever their high bid is that day. After that, you go through the upset bid period, which is 10 days. Anybody else interested in the property, you don't have to show up at the sale. You don't have to do anything beforehand, but anybody can go to the clerk's office and upset that bid by jumping up the bid amount by 5% more than the last winning bid. And just like one before them, they just need to make a deposit of 5% of their bid to secure their place in line. And that process will go on and on every 10 days until it expires with no more upset bids being received. In most cases, people will attend the sale because you can outbid someone else by just $1 to win the bid, but others will wait until the dust settles to see where it is and then just submit an upset bid period. It really depends on the strategy of the buyers. After the property's been sold, it's a matter of just reporting the sale. And that's really just filling out a form, filing it to the clerk, which is a full accounting of everything received from the sale, all the fees, commissions, and other costs of the sale, and then showing what the net proceeds being credited to the balance are going to be. Quickly after, the trustee, as soon as paid, they're going to deliver the deed to the buyer. Transfer of title to the property officially happens. And after that, it's a matter of handling the deficiency balance owing on the loan and seeing if you can recover the remaining amount from any guarantors or borrowers that remain on the hook. But again, that's a strategy consideration to take into account at the beginning, which I'll hand you off to Paul to talk a little bit more about some of those considerations.
Thank you, Thomas. You have gone through the entire process, and we could stop here, but that's not what you all showed up for. I did see that somebody has posted a question, and because I had the chance to read it, I'm going to respond to it, and it fits nicely within kind of the pre-foreclosure considerations. The question is, what are your rights to claw back rents or make them pay twice if they ignore your assignment of rents? Oftentimes, when you've got a deed of trust, you've also got an assignment of rents in place. And so that would entitle the bank to make demand not only on the borrower or the guarantor, but also on the tenant of the property to redirect the rents from the tenant to the landlord or redirect them from the landlord to the bank directly. Under North Carolina law, provided that you make valid demand on the tenant and they fail to pay that rent to the bank has a direct claim against the tenant, regardless of whether the tenant, after the demand was made payment to the landlord. They can be on the hook for to pay twice. So hopefully I've answered that question. Thomas, nice job going through the process. I thought I would start out, Haley, if you would go back to, I think it may be a couple of slides after the checklist. And it should have assessing the real estate and planning ahead piece. and we'll try to go from there. So, after we do our document review and we've had our chance to repair any issues there might be, we're definitely heading toward foreclosure, or at least considering it. First thing we want to do is assess the collateral, assess the real estate, and kind of plan ahead, like Thomas said. The bank has to ask itself if it wants to take title of this property, or better yet, is there any reason why the bank would not want to take title to the property? The first thing that pops to mind are environmental concerns. We get a lot of gas stations. From time to time, you may have a property that has asbestos. If that is even a remote possibility, the bank has probably done a phase 1, if not a phase 2 environmental report, and they're aware of those issues. Now, in North Carolina, I want to make it clear that a bank can take title to collateral and not assume that environmental liability, as long as it's not controlling that property, controlling that business, as long as it's only taking it to turn around and sell it as a normal creditor would do. That's North Carolina law. But even so, there's a risk there, and the bank may not want to be in that chain of title. There may be an adjacent property that has some problems that gives rise. Got a couple of oil cans that have been there for many years, and they used to be full, but they're not full anymore, and you're downhill. So there may be reasons why the bank may not want to take title to the property. In which case, you might want to think about a receiver. North Carolina has a new receivership law in place that is favorable to creditors. It's a new law. It's only been on the books for a couple of years. It allows for a limited receiver that might be able to handle that foreclosure for you and in an efficient manner. So that's an initial consideration. We're going to talk about hybrid auction foreclosure sales a little bit later, but that's also an effort to get interest in the property sufficient to hopefully sell it to a third party instead of the bank having to take title to it with a higher bid. We look very closely at lien priority. We want to know who's in front of us and who's behind us. We look carefully at title work. Some lenders will hire lawyers to do title work. Some lenders might hire a title insurance company and would rely on title insurance. I have one thing to say about that, and that is insured title is not good title. So even if you have insured title and it's not good title, it may create a title claim. And we all know that title insurance companies are in the business of collecting premiums, and they're not in the business of paying claims. And so that's not as good as having clear title to the property. Collateral value is a major consideration when deciding how to foreclose. You want to know what a reliable value of the property is. You want to look at, hopefully you've got a full-blown appraisal, and depending on the type of property, you may want to back out a certain percentage that would cover the time value of money, the time it takes to sell the property, the commissions associated with selling the property. You would want to back out any holding costs taxes, insurance, maintenance, in order to come up with what we'll talk about a little later in the bidding process, a net realizable value. So it's important to have a really good handle on what you think the collateral is worth, what you think you can sell it for, because at the end of the day, you might end up owning it, and then you're going to want to turn it over to CR, to OREO department to sell it, and you want to. That goes into the foreclosure sale strategy. You want to know the status of the property. You want to make sure it's insured. Here this year, we've had no hurricanes in eastern North Carolina. It was expected to be a pretty busy hurricane season. We're in the thick of it now, and I can almost bet you that we're going to have one or two before the end of the year. So what does that mean? You want to make sure that there's nothing that's going to happen between now and the time you get rid of this property that might diminish your ability to recover. And that goes into location. Another consideration is knowing the players. If the borrower is represented by counsel or has a consultant, and that person or professional has a relationship or a reputation one way or the other, that may impact the way you approach a foreclosure sale. We're not going to talk a lot about IRS liens here, but if there are IRS liens on the property, the IRS gets special notice and special opportunities to protect its interests in this process. That is something that we need to consider initially on the front end. Another thing that might impact our decision making is a guarantor or other obligor on the hook. We want to make sure that we've got a loan that we can collect from. We want to look at all sources of recovery, whether that be a collection action, whether that it involves set off of deposit accounts, whether it involves going after personal property of any kind or vehicles. We want to make sure that we consider those so that we maximize our recovery. All of our collection remedies are cumulative in North Carolina and most everywhere under the UCC, and our documents allow the same. So we can choose to exercise our remedies all together at once. We may choose to foreclose first and then sue guarantors later. We can do both at the same time. All of those things we consider. Thomas talked about the elements of a foreclosure, and what we do on our end is put together an affidavit of foreclosure, an affidavit of the holder, which is the lender. And we make sure that we address all of these elements ahead of time in the affidavit. The clerk at the hearing is going to consider affidavits. They can consider live testimony, and we have to be prepared for that. We'll talk about the hearings in a little bit. Again, proving that there's a valid debt, there's a default under the loan documents, there's a right of power of sale provision. The bank has provided proper notice to all parties. Other elements are it's not a home loan, and that the obligor is not on active duty military service. The clerk at a foreclosure hearing can only decide these elements. The clerk cannot consider anything outside of these elements. The only way that the courts can consider that is if the borrower or some other party files a separate lawsuit to enjoin the foreclosure under whatever grounds, be they legal or equitable. So at the end of the day, if we prove those elements at the foreclosure hearing, then we have satisfied our burden of proof to the clerk, and the clerk should enter an order allowing the foreclosure sale. Potential defenses that we see from time to time. People and counsel got very creative during the Great Recession. You would see a lot of harebrained defenses coming up. You would see a lot of opposition at foreclosure, the purpose of which was simply to delay the inevitable. But the ones we've seen before popping up again and again, the bank lacks standing. That's a pretty hard one to prove. But with all the transfers of loans and mergers that we have, that was a lively defense. We want to make sure we avoid that in the affidavit of holder and the evidence we submit to the court. Issues with loan documents, we will have covered that in the loan document review and for the clerk in the affidavit of the holder. And payments, making sure that all payments made by the borrower were credited properly. That is pretty easy to do in an affidavit of holder as well. And improper notice or service, that's another defense that is often raised. And, it's not really easy to get verifiable 100% proof of service. We do everything we can, from posting the property to mailing certified mail, return receipt requested, to overnight mail, sometimes a process server, to make sure that we have proof that we have good service on all of the parties that are entitled to notice of the foreclosure sale. That brings us to the notice piece, and what I haven't covered, Thomas will. Thomas?
Thanks. Yeah, dovetailing right off of what Paul just said. You got to get proper notice of the hearing, and then later on, proper notice of the sale to avoid any of those defenses. And Paul did kind of mention some of the things that we do to try to ensure that we have good service, or at least the best service we can get, to shift that burden to the other side to try to defend it. Number one, the notice of hearing has to obviously go up before the hearing, but it needs to be at least 10 days before. So there's a bit of a window of time where you got to start the process and give at least the parties enough time to respond and prepare to go to the hearing if they so choose. Who receives that notice? Anybody that's identified in the deed of trust, anybody that's obligated to pay the indebtedness, and any record owners of the real estate. We tend to take a broad approach and try to identify all those parties in our title work at the front end to make sure that everybody's receiving notice. And so it's kind of how you try to avoid some of those service of process issues later on in the case. Actually serving it, the best is personal service. If you can't get personal service from a sheriff or a process server, we also attempt registered mail service, which, as pointed out, certified mail, UPS, FedEx, those certified carriers. However, since COVID, we've found mail service to become exceedingly difficult. It's hard to get people to actually physically sign for packages. And so I expect defenses to those types of service to begin to increase as parties are unable to show that they've actually received physical copies of the documents we're trying to serve them with. So sheriff and process server certainly stay the most effective and the hardest to dispute, but it's not always possible. some borrowers, obligors are tricky, they're evasive, and it's hard to pin them down in some cases. That's why as a backstop, we also post on the property itself at least 20 days prior to hearing. That's allowed so long as you can't effectuate service with any kind of reasonable or diligent efforts in the other manners. It's a bit of a backstop. You can't use it as a primary source of service, but if you attempted everything before and nothing seems to be sticking, it's a good one to rely on as a backstop. And so we try to do all those methods of service together all at once and take a bit of a scattershot approach to see what sticks to make sure that the foreclosure process moves forward in a timely manner. And finally, we can also always publish in the newspaper. It's obviously the most expensive option and used as a last resort if all the other methods are unavailable. And so once you've gone through the foreclosure process, you've got your order from the clerk, and now you got to provide notice of the sale. This is a little more cut and dry because now everybody that needs to have notice of this foreclosure has gotten notice already. And so it's a lot easier to accomplish the goal here. Number one, we'll post a copy of the notice at the courthouse. This is usually done immediately following the hearing. Either a member of the court staff will do it or the trustee. Usually we're there at the time, so we make sure it's done and done properly. So there's no question of it getting done later on. We'll mail to each party a copy at least 20 days prior to the sale. We don't need to get registered mail this time. They've already gotten notice, so they should be picking up their mail if they want notice of the sale itself. And finally, we're required to publish it in the local newspaper at least twice before the sale, with the last publication being no more than 10 days prior to that sale. And those two publications need to be at least 1 week apart. So about 2 to 3 weeks before the sale, we have it start publishing at least twice. And that is, as you can understand, in today's day and age, not the most effective way of putting people on notice, but it's still required and a checkbox that needs to be clicked. So that is, in a nutshell, what those noticing provisions are. And we can talk a little bit more about generating interest when we talk about the hybrid foreclosure sale later on. Obviously, these things can be continued by amending a notice and reposting, but essentially that's all that's needed to start forward. But I'm going to hand it back over to Paul to talk about some of the hearing strategies when you're actually before the clerk, before you can get that order entered.
Yeah, thanks, Thomas. Appreciate that. We're bouncing around a little bit as far as the hearing goes before the clerk. We talked about it a little bit so far, but I got a couple of points. Number one, the substitute trustee's role in this, as Thomas says, is to be an independent, third party, neutral. This is a law that came out of the Great Depression. Lender exercising its authority, not even-handed, taking advantage of the poor farmer or resident and foreclosing on property to own it. Now we've got a substitute trustee role. That's another defense that was greatly fought in the Great Recession. A couple of options that we have here. A lot of law firms that do a lot of this work have their own substitute trustee entity. That doesn't work very well unless you're certain that the foreclosure will not be objected to. As long as nobody cares or nobody's going to oppose the foreclosure, having a substitute trustee that is related or affiliated with a law firm is okay. But the minute you have opposition, you got to substitute another trustee who is an independent. There are a lot of different options. One that we use, we've got several independent attorneys across the state of North Carolina that we use on a routine basis that will hold that neutral position. We do it on a flat fee, so we save money for our clients. We make sure that they're responsive and they give us quality work and are available. And as long as we've got those folks lined up to be the substitute trustee, that works out really well. One of the things that you run into a lot is you got either borrowers or their attorneys coming into the first foreclosure hearing and they want a continuance. Well, you know, sometimes we're willing to work with these people, but we've obviously gotten to this point, so that hasn't worked out very well. One thing that we ask the clerk, and of course today in the environment following the Great Recession, clerks are almost automatically going to give at least one continuance. Hopefully it's only 30 days. I've had them give as much as 90 days of a continuance. You want to avoid that because you don't want the delay to make the situation worse. One suggestion here is, say, clerk, that'd be fine. Why don't we get an order entered today and we'll agree to push off the sale another 30 or 60 days. That way you don't have to come back in front of the clerk for a hearing. You avoid that expense. You've got the certainty of the order. And by that time, it's too late to appeal the order. And so you move on down the road with your foreclosure. Another tactic that I've used successfully is, the clerk is going to order the continuance, but if you ask the clerk to put in language that there will be no further continuances, at least you cut off that potential delay tactic by the other side. If you got a settlement in the works, you got to keep it tight. You got to put hard deadlines on it and look for opportunities to get waivers from your borrowers. Waiver of notice is enforceable in some cases. Waiver of the process in some cases can be allowed and enforced. Waiver of the automatic stay in very tight confines can be approved by a bankruptcy court in a future bankruptcy case. Pretty rare, but it does happen. So just some things to think about strategy wise. Thomas, why don't you run through the hybrid auction foreclosure process that we've had some success with lately?
Yeah, foreclosure auction hybrid is something that a lot of banks don't really think about, but we've seen a lot of success with it. And to be clear, we're not talking about substituting the foreclosure process, but supplementing. As Paul mentioned earlier, the idea of bringing in an auctioneer is to generate interest, to really rely on their already established network to bring in potential investors, people that are not normally checking the courthouse bulletin board for foreclosure notices or reading the newspaper for foreclosures to try to find a good deal. You bring in an auction company and they're going to assist the trustee, they're going to work with the bank and try to work out a bidding process that works and tries to generate the goal being a third party purchaser that buys everything out and reduces the risk that the bank is going to have to take the property into REO. So obviously there's some real great advantages to using an auction company because you're relying on that marketing power, you're relying on their advertising, whether it be newspaper or posting it or putting it online. You're going to reach a whole lot more people than you would by just following the bare minimum statutory procedures of posting a notice. You're going to end up bringing in investors that normally wouldn't be looking for real property like the one you're trying to sell. And at the end of the day, you're just going to have a much stronger chance at getting it unloaded to somebody else rather than the bank. And another final consideration that you don't really think about is the theatrics behind it. An auctioneer and all of the pomp and circumstance that comes around it, the fast talking and the bidding process, something a lot of people don't really get to see firsthand. And so when you're there at the courthouse, wherever the sale's being held, and you get a chance to see that, it gets people excited. People that aren't really there to bid but watching might kind of get caught up in the moment a little. They know they've got interest and want to bid. Maybe they start participating. Maybe they're not the high bidder, but maybe you get some people to throw out some bids to generate interest, to get other people bidding, get some back and forth, and maybe that bid price goes higher than what the bank imagined, and certainly could eliminate any need for the bank to submit a credit bid in itself. The limitations are obvious. You got to have a contract with the auctioneer. You got to pay for their services. They don't do it free, but if you can get a successful outcome, it's usually much worth it. They're still limited to the confines of the foreclosure process, so you can't just go off the rails and do it however you want. You can't have online bidding. You can't require people to pre-register or follow any conditions before they can bid. You can't require premiums like some auction companies would require, or a reserve price. But as long as you're following the statutory process, providing notice, allowing everybody that wants to bid the ability to bid, then you're usually perfectly fine. You also can change the location of the auction. Maybe you don't want it on the front steps of the courthouse. Maybe you want it at the property itself. That has a tremendous advantage because other bidders can show up, inspect the property themselves, answer some of their own questions. They're not distracted by the courthouse. They don't have to worry about looking for parking. Sometimes it's a little more comfortable, and it allows that auction company to kind of separate themselves from the actual foreclosure process and make it feel like it's its own separate auction that's being handled. If you do handle it at that location, just be warned that it's only allowed if the deed of trust allows for it and the borrower consents. Remember, it's still their property. They still own it until it's foreclosed and the deed is transferred to a new borrower. So you can't do it in every case. If the deed of trust is silent on the issue, you're restricted to the courthouse. But if the documents allow for it and the borrower is on board, it's just another advantage of an auction company that you can rely on. Again, I did mention you got to pay for the services, but that doesn't mean you're confined to whatever they're going to require you to pay. You do have some control over the contract process, and you want to make sure that we get ahead of it and help massage that contract to account for a lot of different situations and tailor it to this specific foreclosure you're handling. Try to adjust that compensation structure. There's a lot of outcomes at any foreclosure sale, and you want to be prepared for what the bank's going to have to pay at each of those outcomes. Is a third buyer going to win? They get a good price. Maybe you offer an attractive commission for making that happen. What if the bank is the highest bidder and maybe the commission's lowered, or there's a lower flat fee if they don't get someone else to buy? What if you have a workout, or there's a bankruptcy filing, or something that terminates the entire process before the sales final? Maybe there's a separate fee for that that's lower as well. So you're not stuck paying a high premium without getting any results from it. Maybe the buyer that wins at the auction backs out. Well, maybe you massage those provisions to make sure that the auctioneer gets compensated fairly and hold their feet to the fire to participate in a resale. What are the terms of that resale? Just certain considerations that need to be taken into account just because of the myriad of different resolutions you might run across. And another consideration is maybe there's personal property at the location. Do you want to handle this all together or separate sales? Usually there's separate statutes that govern how to liquidate personal property versus real property. Is this a restaurant where the equipment makes sense to keep in there and you want to sell it together? Possibly. Maybe this is a business with some really highly marketable and specialized equipment that can generate its own value on the market separate from the real estate. These are other considerations you can take into account early on to figure out how you want to streamline this process to get the most money through it. And Paul, if you want to talk a little bit more about some of the bidding strategies that you can talk about with your auctioneer, and right from there.
Yeah, that sounds good. Bank has the right to credit bid, and that is a right, by the way, that cannot be taken away even in a bankruptcy case. How to calculate the bid takes a little bit of noodling. You have to consider senior liens. You have to consider junior liens. You want to consider property taxes. Ad valorem property taxes in a lot of counties need to be paid before a deed can be recorded. And so the bank needs to consider how it's going to calculate its bid based partially on that. A foreclosure wipes away the lien on the property once it's completed, as of the deed of trust you're foreclosing on and anything junior to it. Ad valorem property taxes are always senior. We know that. There may be other taxes that come into play, but if there's a lien behind you, it's going to get wiped away through this foreclosure process. A senior lien, let's say there's a deed of trust ahead of you, that does not get wiped away by the foreclosure. So when you're coming up with your bid, you don't want to include the first lien because that would not be wiped away in the foreclosure. You got to be aware of that when coming up with your bid. You want to understand the senior lien. You want to make sure that you're prepared, if necessary, to pay the senior lien. Because once your foreclosure process is over, either the senior lien gets paid or they can then start their own foreclosure process. That's where the net realizable value of the collateral comes into play. Generally speaking, you want to bid the lesser of the net realizable value or the payoff on your lien. If there's a lot of value in the property, or if you hold the junior lien, you may consider bidding enough to cover your lien on the deed of trust you're foreclosing on, plus assuming for sure you're in the next position, you may consider, if the value is there, bidding more than that, so that any proceeds over and above the deed of trust obligation or indebtedness you're foreclosing on would go to pay down the junior lien. You want to keep in mind that you've got a payoff with all sorts of components. You've got principal, you've got interest, you've got late charges, you've got fees, you've got appraisals, you've got attorney's fees and legal expenses. You may have allowed under your documents a trustee's fee. If there's value, the North Carolina law allows you to bid that much. So a lot of noodling needs to go into the credit bid and how it's calculated. If you've got your credit bid, when do you share it and when do you not share it? A lot of people hold a different opinion about whether you should share it or not. I personally believe there's no harm in sharing it. Hopefully it will garner interest and bring bidders to the sale, and they'll be prepared to bid. I know we're running short on time, so I'll go quickly a little bit through the rest of the program to leave a couple of minutes for Q&A. Upset bid process. This is a big one. You get a credit bid, and that means that the bank can bid its debt or up to its debt. It can also bid more than its debt, but you can only credit bid up to its debt. If you have more money that the bank is bidding over the credit bid, it might have to put down a deposit. In the upset bid process, that's a 10-day period after the sale, and anybody can upset the bid, has to pay 5% more, and has to put down a deposit in cash of at least 5% of the total bid. That 10-day bid deadline runs successively. We've had situations where upset after upset are filed successively, and it goes on for months, which is a good problem to have when you're the foreclosing lender. Once the upset bid period expires, then the title to the property passes to the high bidder, and the rights in the property are then fixed. And so it's important to understand, as a foreclosing lender, you can dismiss the foreclosure at any time before those rights are fixed. If you find out that there's a defect in the process, or what you believe to be true turned out not to be true, you can always dismiss that foreclosure and end that process. Don't always want to do that because you might have to start it from scratch and lose out on some of those expenses that you've already incurred that may or may not be collectible. So we're reaching the end of our presentation. Thomas, you want to take a couple of the questions in the finite time that we have left?
Thomas, are you able to see it, or do you need me to read?
Yeah, I see we have one more question here about addressing if you're a non-bank lender, want to increase your collateral position, avoid foreclosure, perhaps bankruptcy. You know, what can you do? Can you move that property to an LLC controlled by the lender?
Yeah, I'll be happy to chime in on this one. And thanks, Vince, for taking us down a rabbit hole a little bit outside the scope of this presentation. But you know, what we're talking about is requiring a borrower to put property in a remote entity, oftentimes controlled at least partially by the lender. And that is an effective way to prevent effective opposition to a foreclosure sale. It's also an effective way to prevent the property being tied up in a bankruptcy. There are a lot of risks that are associated with that. You want to make sure you're not controlling the entity or controlling the property too much. And it has to be papered up. You have to have consideration. You have to have hypothecation to make sure that any pledge is valid. So you got to paper it up, and it's a little complicated, but happy to help effectuate that in the right circumstances.
It looks like we just have just one more minute. So I'm just going to ask, can you give us an example of where a foreclosure auction hybrid may be particularly useful?
No, that's a good question. When we're talking about those situations and generating that extra interest, it's going to be when you're talking about some property that's got high value. You know, maybe it's resort property, maybe it's a hotel, and it's stuck in a very rural part of North Carolina. You know, someplace where there's not going to be a lot of people aware of that sale, but there is certainly a cross section of investors who may be interested in it. And you really want to be able to reach that population and bring in people that would not normally stumble across this sale, put it on their radars, and come and bid on that property. So utilizing that marketing power of the auction company is going to be the only way that a lender can reach out to those investors not close by, and kind of reduce that likelihood of the bank having to take title to this property into REO.
Great. Well, thank you guys. Thank you, Thomas and Paul. Thank you guys for being patient with me as I figured out the slides. For those of you in attendance following this webinar, you will be sent a recording of this session as well as a copy of the slides. We appreciate you taking the time to join us and hope that you are able to take this information you learned today and apply it to your business. That's going to conclude this webinar, unless Paul and Thomas, you guys have anything.
Thank you very much. Have a good day.
Thank you.